judicial body, and therefore it cannot execute or give itself judicial functions in this matter. Many of you are aware that the referral that the UN Security Council did to ICC on President Al-Bashir was very contentious, in the sense that it is a non-judicial body that was triggering the last court of resort globally to act. Meanwhile, the last court of resort in the principles of law must be triggered by a subordinate court lower than itself, because the subordinate court would provide an opportunity for the person who is the subject of that matter to be heard before the matter is referred to another superior court. And because of this, I want to emphasize this, that the entire African civil society movement will defend the credibility, the integrity of this union, the integrity of this continent, and no kangaroo court shall ever come and disturb our political, economic, social, governance, and human rights agenda that we have. Africa is well known for its functionality in law, in governance, and human rights. Challenges are everywhere, but we always add value to any judicial system. And many of you are aware that the heads of state and government did provide to extend the mandate of the African Court on Human and People's Rights to have jurisdiction over international crimes. That in itself is render credibility to the ICC, so that the ICC could be taking on matters that are not sufficiently handled at a subordinate level. That is what Africa is. While everybody is busy talking about the value of ICC, we are talking about the value of the justice system, the value of the rule of law, the value of what complementarity in law is supposed to be. In conclusion, before I ask my colleagues come in, I want to emphasize this, that the attempt of the last 48 hours is actually an indictment on the ICC itself and its collaborators. That no matter what you do, for as long as it is not legally sound, law shall never be manipulated. It is an indictment on them and their collaborators that matters of this nature shall never be tolerated on this continent. And I think we will be recommending to various police organs of the Union that we move quickly on the decisions that were made. The directives that were made were one in January, that the African Union interfaces with the UN Security Council and discusses the matter on the way forward, since the matter was referred away from the ICC court. Secondly, that we interface with the ICC as well, so that we can lay the matter to conclusion for reason that it lacks substance in law and that it is also an illegal act, and that a sitting president enjoys immunities under the UN Vienna Convention, and there is no provision in the indictment that set aside the provisions of the Vienna Convention to effect an arrest on someone who is enjoying diplomatic immunity. Ladies and gentlemen, this is what I wanted to briefly say to you. Thank you.
Thank you, Joseph Blingi, for this presentation. And I would like to announce that this press conference is organized jointly between ECOSOC and National Group for Human Rights, Sudanese-based national NGO operating in human rights fields. So our second speaker will be Professor Daniel Makasi. David Hoyle? Okay, David Hoyle He is a British Academy expert in ICC. Would you please have the floor?
Well, thank you very much, Mr. Chairman. I think that the events of the last 48 hours will in fact be seen on hindsight, or with hindsight, as being a watershed, not just for the African continent, certainly for the African Union, and also I think actually for the International Criminal Court. It has actually put into sharp perspective, sharp contrast, a number of the arguments that have been in play with regards to the court itself, its credibility, its legitimacy, and its interaction with Africa and the people of this great continent. The simple fact is that the court that many African states signed up for enthusiastically, not just African states, but a number of other states internationally, signed up for internationally since 1998, is not the same court that Africa finds before it today. That court was a court that actually set out claims that it would actually pursue injustice and very serious cases of injustice without fear or favor. The reality is that it has spent the last 12 years showing itself, proving itself to actually be a deeply dysfunctional court, a court that has been mired in irregularities legally, a court that has been mired in prosecutorial misconduct of a nature that in most Western states the prosecutor would have been disbarred and probably even himself prosecuted for perverting the course of justice. You have also seen manifest evidence that far from being a universal court, as the ICC has actually presented itself as being, boiled down to a European court for Africa. This institution that says it is that claims to be a genuine universal international court is very far from that. It only represents, for example, maybe 1/3 of the world's population. The United States is not a member, Russia is not a member, China is not a member, the world's biggest democracy, India, is not a member, and so on and so forth. It is many things, but it is not the international court that it claims to be. It is at best a very flawed European court for Africa. The ICC has also claimed to be independent, but at the same time, this claim is just so ludicrous because it actually affords its own statute, grants the United Nations Security Council special prosecutorial rights. So the world's most political body, made up of politicians with varying political agendas, has a prosecutorial input into the day-to-day affairs of the ICC. So it's certainly not independent in that sense. This is also a court that actually says it is truly independent. The independence of any court, of course, depends on its funding. The reality is that anywhere between 60 and 66% of the funding of the International Criminal Court comes from the European Union. So this is, in effect, a European Union funded, European Union directed institution that has shown itself to be nothing more than an instrument of European foreign policy. And for those of us who hail from the African continent, the simple fact is the big five funders of the ICC are the big five former colonial powers within Africa. That's to say the United Kingdom, France, Germany, Italy, and Spain. So there is, right from the start, an overwhelming déjà vu that this, in fact, has been claimed to be an instrument of neocolonialism. And in many ways, that case is very, very sound. This is also a case, a court that, as mentioned, has had a history, a continuing history of dysfunctionality. You have had examples within the court where the chief prosecutor, for example, has actually tried to hide hundreds of items of exculpatory evidence. That's to say, evidence that might have proved the innocence of a defendant. Hide this evidence not just from the defense, but also from the judges on the ICC bench. You have had cases where judges at the ICC have tried to introduce new charges halfway through a court case, a very serious court case. This again is just sort of so unlike any established legal practice that it is in fact almost unrecognizable. This is a court that also tries to present itself as dealing with some of the most serious and intricate allegations of war crimes or crimes against humanity or genocide that the world has ever faced. And yet it has appointed as full ICC judges, judges who have never been lawyers, let alone judges in their career. And in some cases, their only qualification is that they spoke English. So even the most junior rural magistrate in this great country of South Africa is better qualified to be a full ICC judge than many of the people that are sitting in judgment on Africa today. There is no great surprise, therefore, that the ICC's cases in Kenya, the Kenyatta case, for example, amongst others, have been caught up in scandal after scandal because of ICC misconduct. There's no surprise that the chair of the bench that has actually been trying to examine this issue is herself a Japanese diplomat with no previous experience as a lawyer. So these are just some of the issues which I think have come up from time to time and continue to be at the forefront of Africa's concerns, amongst many other concerns, on this issue. So we have seen a large amount of valuable African Union time wasted in the course of the last 48 hours by and through nothing more than European ICC game playing. Thank you, Mr. Chairman.
Thank you, David. Before we give a chance for questions and comments from your side, let us present. Yeah. Professor Daniel Makasi, the acting chairman for African Union Commission for International Law. The floor for you.
Merci, Monsieur le modérateur, pour la parole. Je tiens d'abord à saluer l'intérêt de médias qui, en réalité, servent de vecteurs et de courroies de communication avec les opinions publiques nationales, continentales et internationales. Et l'intérêt est partagé sur cette question. Mais il est très important de souligner ici que le temps du droit diffère du temps du journalisme. Le droit ne doit pas être traité avec un esprit de sensation, avec un esprit de précipitation, avec un esprit d'instantané. Le droit et la justice sont des institutions tellement importantes qu'il faut éviter de le traiter avec un esprit purement journalistique. Je suis persuadé que les journalistes qui vont traiter de cette question puissent tenir au minimum compte de principes de droit, des instruments de droit. Sinon, ça sera de la spéculation. Je sais qu'il y a des journalistes économistes, je sais qu'il y a des journalistes internationalistes, mais je sais que ça doit être difficile de trouver facilement des journalistes juristes. Cependant, je vous interpelle à ce que dans vos articles, vous puissiez vous référer au texte juridique, parce que là, vous traitez une affaire internationale juridique. Ceci dit, je tiens à souligner quelques éléments essentiels. Dans la pratique des États, depuis la nuit de temps, les immunités diplomatiques ont été acceptées et sont devenues même une coutume internationale. Et pour cela, il n'y a pas seulement des conventions internationales, mais il y a même la jurisprudence internationale qui consacre l'inviolabilité des officiels. Il est vrai qu'à la suite du statut de Rome, il y a eu une évolution. Mais cette évolution ne porte pas encore atteinte de manière effective à cette tradition des immunités diplomatiques, fondement même du droit international. Il est évident que dans le statut de Rome, on évoque la non-pertinence de la fonction officielle. Mais là, c'est en termes conventionnels. Par la suite, ici, il est question plus de se concentrer sur la poursuite et la compétence. Donc, il y a des doctrines, il y a des principes de manière générale, mais par la suite, il y a des questions de procédure, il y a des questions de compétence, il y a des questions de poursuite. Pour ce qui est de poursuite et de compétence, là, nous sommes en droit international pénal. Nous avons quitté le droit international général. Le droit international général consacre les immunités. La jurisprudence aussi consacre les immunités. Je peux vous renvoyer à bien des arrêts de la Cour internationale de justice, mais je ne me trouve pas devant un auditoire de juristes, mais je tiens à souligner l'essentiel qui peut être retenu. Donc les immunités est une coutume internationale qui ne se discute pas, malgré la non-pertinence de la fonction officielle inaugurée par le statut de Rome. Deuxième élément, il y a le droit international pénal qui vient en évolution. C'est-à-dire, nous avons désormais des conventions qui consacrent les infractions, les crimes internationaux. Mais là aussi, il faut noter qu'il y a des principes et des règles. Je m'en vais seulement vous évoquer ici le fait que par désaccord, on peut bloquer la poursuite, on peut bloquer l'arrestation d'une personne poursuivie dans le cadre du statut de Rome. Le statut de Rome le prévoit ces accords au niveau bilatéral, mais dans le cadre de l'Union africaine, nous n'avons pas seulement, nous ne sommes pas au niveau d'un accord bilatéral, nous sommes au niveau d'une décision régionale et continentale des chefs d'État. Qui, de plus que les chefs d'État, engagent la responsabilité et les obligations des États en droit international. Donc les chefs d'État au niveau africain.
Well, you are watching a live broadcast coming to you from the Sandton Convention Center here in Johannesburg, in Sandton. And the people you are seeing now, it's a group of people who have come together to speak on the matter of President Al-Bashir. The person you are seeing there is from the African Union's Commission person responsible for international law, and the person you saw earlier was a writer, someone who has been dabbling in the ICC's area of work, and throughout this summit has been speaking to several news organizations just about his criticism and the writings that he has produced over the workings of the ICC. Some of you will have seen yesterday we did have him on our show as well. He was talking, he was basically talking, taking us through some of the problems that he has identified with the work of the ICC. Earlier on, you saw Joseph, who is the gentleman, the third gentleman from the four that you are seeing there, who was also talking about how, in fact, the very referral, though it came through the UN system, but the very referral of the Al-Bashir matter to the IECC was never without controversy. Something, of course, that has been said by several people before. Well, those gentlemen will be taking questions in a short while, but we thought we needed to give you that context, that the people you are seeing there right now are people who felt the need to come together, and given that this has been a topical issue, they felt the need to speak to some of the issues that have arisen since this matter came to the fore the day before yesterday. So it's people from Sudan, civil society, but an expert who has been dealing with this issue, but also someone from ECOSOC, which has also been speaking on this matter. Now, before we go to the questions that will be raised, I think from the floor, it is perhaps important to highlight or to put into perspective a couple of issues. The issues that the gentlemen you've just seen now are raising are all the issues that members of the heads of state of the African Union, the Commission, the commissioners of the African Union, but also member states from their own vantage points. They have been raising these issues. These are the issues that South Africa, for example, has said are important to it, and they are the issues that have informed their dissatisfaction with the ICC, how it operates, how it brings issues up for prosecution, and so on. But what these gentlemen are saying, and what several people, whether they are from, we had Obed Bapela yesterday, who is the ANC's head of international affairs, but we have also spoken to people from the AU itself. What they do not speak to, which in essence, if you've been following this story, what other people who have a different point of view have been saying, is that if the ICC is as fraught with the sort of challenges that have been raised, why then are African nations, including South Africa, continuing to support the ICC? Because at issue here is that South Africa had decided on its own to form part of the system. Not only did they do that, they then went further. Our government went further to make it our own law. In other words, what is being asked for now is something that we have subscribed to, not only through Roman statutes, but we've made it our own law. That is where the argument that we should have handed over President Al-Bashir so that he faces prosecution comes from. And the gentlemen who were there are not speaking to that. We do hope, of course, to bring you people who can speak to that issue. We did yesterday try to bring you through the ANC, the head of the ANC's international desk, Obed Bapela, to sort of try and speak to those issues. We hope to bring you people from the African Union, but also from South Africa, from our own government, who can try and explain those issues. Because beyond the technicalities and the arguments that are presented here are millions of Africans who are suffering because some dictator in some corner is able to use his or her power and influence to try and oppress millions of Africans who have no hope. And because the ICC is a court of last resort, there are a lot of people who are dependent on it to actually deal with the dictators who continue to oppress people, millions of people who are vulnerable and who have nothing to protect them from all corners of our continent. Those and more, those issues and more, we hope to bring to your attention, or at least to try and explain to you. For now, though, let's go back to that briefing and hear what people who have questions or questions of clarity and so on have to say, and what those gentlemen will have to say in response.
as a racist organization. I just wanted to understand how you reconcile that with your membership in the 1980s of the Federation of Conservative Students when you were pictured wearing Hang Mandela stickers.
Well,
okay.
I'm afraid
before you can take another one.
Well,
yes.
let's actually do this one now.
Another chance, yes. Yes, okay.
Okay. I'm afraid what you read on the internet, as I'm sure as a journalist, and you may also be party to this now, is very often, very seldom.
It was photographic proof?
Well, I haven't seen it. It's very, very seldom the truth. Perhaps unlike you, I've actually met Mr. Mandela, and I think that he has been one of the greatest statesmen this country and Africa, in fact the world, has ever produced. So events 30 years ago, which have no bearing sort of factually or otherwise on what's happening now within this continent, I think have no place here. I can actually discuss being a member of the Conservative Party in Britain, being a member of the National Executive of Margaret Thatcher's Conservative Party. It's true that Mrs. Thatcher's Conservative Party had a very negative perspective on the African National Congress, and I think also on the PLO. That may well have been the case actually 30 years ago. If that was the case, that was very, very inaccurate. And I'm very surprised that a person from a very respected news agency would actually try to introduce very scurrilous and propagandistic nonsense into an issue which is very, very important.
Yes. Another? Yes.
Thank you. Tulas Izwasimelane, ENCA, South Africa. My question is, at what point do we move the conversation beyond the current case of Omar Al-Bashir? At what point do we not risk being seen as, being obsessed with shielding Al-Bashir at all costs? At what point do we as Africans, do you, sitting there at the front, take the campaign that says, on this continent, horrible things do happen, and we know this. In the DRC, we've seen it in areas such as Goma. We see it all the time in various parts where there's conflicts. At what point do you agitate for African leaders to establish their own mechanisms to prevent such things as what the UN Special Representative on Sexual Violence, Zainab Bangura, was talking about a few days ago, where you hear of a 6-month-old baby being raped in conflicts? At what point do we then move the conversation beyond Al-Bashir?
Okay, another time. Yes, your name and affiliation. Yes.
Hi, good afternoon. My name is Renee Volgraaf from Bloomberg News. My question, I think, is to Mr. Chilengi. Sir, is there a possibility that the AU and your organization might encourage its members to withdraw from the Rome Statute and the ICC?
Okay, the last one before we go to the panelists. Yes. Yes, here.
Good afternoon, panelists. I'm Gladys Itole, representing African News Network, also known as ANN7. My question is, looking at the numbers of the countries that have signed that treaty or the agreement with the ICC, African countries make part of, in fact, a majority of the countries that have signed there, with 34 African countries on there, and the rest of the other continental states making up 19 or 3 or whatever. Why is it that now Africa comes forward and says that we are now being bullied by the International Criminal Court when majority of our countries are the ones who have signed up for that? And why do we not have the power to make the changes that we want to see with in the numbers that we already have within the ICC?
Joseph. So yes, Chilengi, and then we can go for a second round.
Thank you so much. Let me start with the last question. Why Africa, we are the majority, and meanwhile we are complaining that we're being bullied. Our initial approach to the ICC was that it was a a very good base of a global court. That was our understanding. And even if we take blame most of the time that Africa does not seem to raise the bar, we have raised the bar at most fora, but I think we just don't blow our own trumpets. Africa, as you have said, has the majority of the state parties to the Rome Statute. And with an understanding that this will be an international court with international jurisdiction that is going to function as a fair court without an agenda to constipate the international justice system and to behave in a manner that contradicts the rule law system, which is also contrary to the UN Charter to which we all subscribe. So it's the behavior and the attitude of the court that has made us to begin to see whether is there any value addition to the continent on this matter. And I will give you examples. One, we have a question on the international jurisdiction character of the court, because it has concentrated only in one region, even when there are more serious cases committed in other regions, including Europe and the United States of America, which America says we are not a member of the ICC, and Sudan is also not a state party to the ICC, but the ICC has ceased to be an instrument of a justice system to an instrument of a political justice system. And that is one reason we have had problems. Secondly, Africa made a proposal that if this is an international court that is mandated with international crime, the crime of aggression is also an international crime. Can it also come under the jurisdiction of the international court? I have it in writing. The European Union says we'll never support you on this matter. But aggression is an international crime. And we have an international court. So why can't that crime come under the jurisdiction of the international court? That is one issue of contention. Secondly, our contention was that the ICC is the last court of resort. It must be triggered by either insufficiency or inability or not satisfaction at the lower level to trigger. We saw it triggering itself, and I know where you are coming from to say these were made as referrals and so forth. So this is one reason that you see that we are making changes ourselves. Now, how do we go beyond the Al-Bashir issue? We have now a protocol on the African court with expanded jurisdiction. As soon as it receives the necessary ratification, that protocol will now give birth to an African court on human and people's rights with jurisdiction over international crime, and therefore we would begin to perfect the international justice system, that the lower courts shall deal with matters before upper courts coming. And at national level, we have also moved in Uganda, in DRC, there are national jurisdiction to try international crime. So we are assisting the international justice system by perfecting it. But no one recognizes the role of Africa in this regard. I thought I should mention that, unless my colleague has any comment to make.
Merci pour la parole. Je trouve injuste de dire que l'Afrique n'a pas la capacité de juger les Africains. Je vous ai parlé du cas du Sénabré. Donc, la justice sénégalaise, conjointement avec les experts de notre continent, ont déjà lancé cette procédure. Mais il est évident que la justice a son temps et la justice a son coût. Pour trouver des preuves, pour ne pas fabriquer les preuves. Et donc, il ne faut pas recycler ce que d'autres disent sur l'Afrique. Donc, il y a déjà un précédent, il y a une procédure. L'Afrique n'est pas dans une logique à soutenir l'impunité. Non. Le cas du Sénabré est un cas clair et net où un Africain sera jugé par une cour africaine, conjointe justice sénégalaise et les instances de l'Union africaine. Nous avons la réforme en cours dans le système de l'Union africaine. Donc très bientôt, nous allons encore une fois attester la capacité de l'Afrique en prendre en charge elle-même des réponses judiciaires sur des questions ayant trait à des crimes internationaux. Mais il y a un principe fondamental en droit et particulièrement en droit pénal. La présomption d'innocence. Ce sont des principes très chers qui donnent de la crédibilité au droit et à la justice. Imaginez si le président kenyan n'était pas présenté à la CPI, on aurait tout dit. Mais laissez-moi constater ici que dans le traitement, non pas seulement médiatique, mais surtout judiciaire.
Well, pertinent questions there being asked by some of the journalists who are attending that particular briefing. Well, anyone who, in case you've just joined us, it's a briefing being given by Sudanese representatives, one of them from civil society, another one an academic who has been writing quite a lot on this matter, but also a representative from one of the committees of the African Union, just explaining the problems they have with the entire ICC system. But of course, journalists, they are asking some of the pertinent questions really about, among those questions is the issue of why, for example, blame the Western powers, why blame the West when in fact you submitted to this organization freely and on your own free will. Well, that's where we're going to leave it for now, but do stay with us. We are going to try and make sense of some of these issues as we go along. For now, though, it's back to Johannesburg.